Today, we're going to dive into a legal drama that's over 150 years old, but believe it or not, still shapes the agreements we all make every single day. We're talking everything from a software subscription to buying a house. It's a fantastic story of high art, high stakes, and one contract that went seriously sideways.
But let's kick things off with a question that really gets to the heart of it all. When is a promise so important that if you break it, the whole deal is off? And when is it, just a minor hiccup? Well, this is the exact puzzle that a court in London had to figure out.
All right, picture this. It's 1875 in London. Our story unfolds in the glamorous but absolutely ruthless world of 19th century opera. We're at the Royal Italian Opera in Covent Garden, a place where careers were made and fortunes were lost, sometimes on a single performance.
Now, we've got two main characters in this drama. On one side, there's Alessandro Bettini, the starred tenor. He's the main attraction, the big name, hired to bring in the crowds. And on the other side, we have Frederick Guy, the impresario. He's the powerful producer, the guy whose money and reputation are totally on the line.
And what brought these two powerful men together? A contract, of course. And like any business deal, it was basically just a series of promises. But as they were about to find out, not all promises are created equal.
So here's the deal. It was a 3.5-month gig for Bettini to sing in all sorts of performances. The pay was pretty good for the time, and the stakes were high. But tucked away in that agreement was this one little clause. He had to be in London for rehearsals at least 6 days before opening night. Seems simple enough, right?
Well, this is where our story really gets interesting, because real life, as it so often does, had other plans and was about to throw a major wrench into this carefully crafted contract.
Bettini got sick, and it wasn't just a small cold. It was serious enough that he couldn't travel. So instead of arriving 6 days early, he gets to London just 2 days before his first performance. He ended up missing 4 of those 6 crucial rehearsal days.
So how does Guy, the producer, react to this? I mean, he could have been understanding, right? Maybe rescheduled a few things. But no. Instead, he made a huge, dramatic, and very decisive move.
He didn't just fine Bettini or ask for some kind of compensation. Nope, he flat out fired him. He refused to let the star tenor even set foot on the stage and declared their entire multi-month agreement was completely void, all because he was 4 days late to rehearsals.
And this is the million-dollar question that lands them in court. Was Jay's really extreme reaction legally justified? Did Bettini's failure to show up for a few rehearsals give Jay the right to just rip up the whole deal? Bettini, of course, sued, and it was up to a judge to decide. Now, to answer that, the court came up with this really powerful legal idea, a way to tell the difference between the big, important promises and the smaller ones. And this distinction between what's called a condition and a warranty is this case's most important legacy.
Okay, so first up, you've got a condition. Just think of this as a main pillar holding up the whole building. It's a promise that is so fundamental, so absolutely essential, that if you break it, the entire point of the contract is destroyed. It goes, as the lawyers say, to the very root of the matter.
And then, on the other hand, you have a warranty. This is a less critical term. It's still a promise, sure, but it's more of a supporting detail, not the main event. If you break a warranty, it's a problem, but it's not going to make the whole building collapse.
And here's why this distinction is so important. The consequences are totally different. If someone breaks a condition, you can walk away from the entire deal and sue them for any losses. But if they only break a warranty, you can sue them for damages, but you cannot cancel the contract. You still have to go through with your side of the deal.
So, how did the judge use these ideas in the big showdown between the opera singer and the producer? Was that rehearsal clause a deal-breaking condition, or was it just a minor warranty?
Judge Blackburn's entire decision came down to this one simple question. Did missing a few days of rehearsals completely ruin the whole point of a 3.5-month singing contract? His conclusion, summed up perfectly in this quote, was that it was a breach, sure, but it wasn't one that went to the root of the matter.
So he ruled, very decisively, that the clause about showing up 6 days early for rehearsals, that was just a warranty. Yeah, it was an important promise, but it wasn't the absolute core of the deal. The court's logic here was really straightforward. Look, Bettini was hired to sing in operas and concerts for months on end. Missing a few rehearsals might have been an inconvenience for Guy. Absolutely. But it didn't make it impossible for Bettini to perform for the next 3 months. So Guy was wrong to cancel the contract, and he ended up owing Bettini damages. So why on earth are we talking about some dusty old case from Victorian England? because the simple, brilliant logic from Bettini versus Ye is still used every single day to solve all kinds of modern problems.
This one principle helps us sort out countless disputes by asking that exact same question. Does this failure go to the very root of the deal? Think about it. Is a bug in a new app just a minor annoyance, or does it make the whole thing unusable? Is a 2-day shipping delay a problem for a textbook, or is it an absolute deal breaker for a wedding dress you need for Saturday? The difference is everything.
And that really leaves us with a final thought. The next time you sign something, anything, a new job, a phone plan, a rental agreement, just take a second and ask yourself, what are the promises in here that are so essential to me that if they were broken, this whole thing would be pointless? Because trust me, knowing the difference between your conditions and your warranties, well, that's everything.